Today I want to go over a sort of David and Goliath moment in trademark law that came across my feed a little while ago. Activision / Blizzard is suing Warzone.com LLC. It's a trademark infringement lawsuit, and I think you'll find it very interesting. The place I want to start is the defendant, Warzone.com's counterclaims against the plaintiff, as I think this tells the story from the defense perspective. Warzone has adopted the trademark Warzone TM and has established common law trademark rights in the Warzone mark. That's different than when you register a trademark. Common law trademark rights means you've been using it in commerce, and by its use in commerce, you've automatically got some kind of trademark protection. It's less clear what you have than when you have a federally registered trademark, but here we are. Warzone has been making continuous and ongoing use of the Warzone mark in US commerce since at least as early as November 13th, 2017, in connection with providing its online and downloadable video game of the same name. 2017 would be before Call of Duty Warzone came out, so it seems like, at first glance, that Warzone.com, which is how I'm going to refer to the senior mark, and I'll refer to Call of Duty Warzone as Call of Duty Warzone, that would be the junior mark, assuming these dates are correct. Warzone treated the Warzone mark as a trademark by consistently using the indicator TM after the word Warzone in its logo. Warzone owns a pending US patent trademark application for the mark Warzone under International Class 09 for use in downloadable game software for use beginning on or about November 13th, 2017. They also own a pending application for Warzone under International Class 41 for non-downloadable game software. They're going to refer to these as the Warzone applications. I'm going to call them the Warzone.com applications. Since its launch in 2017, Warzone has devoted significant resource to developing a loyal customer base and ensuring the consistent quality of its goods and services under the Warzone mark. It was at this point that I got curious, what the heck is the Warzone video game? Because, you know, I play video games on Steam. I get video games marketed to me all the time. So what the heck is Warzone? Well, this is Warzone. Note that there's a little Activision is suing us bubble in the upper left. And when you click on the game and you go to play it, it is very much a Risk-style game. In fact, if you go back here, it says so. It says, if you like Hasbro's Risk game, you'll love Warzone. Play alone or with friends. Risk is a registered trademark of Hasbro. Warzone is not affiliated with Hasbro. You get territories, you get armies, you assign your armies to an area, and then you invade an area, and you try to take over the world while everybody is doing the same thing. But it doesn't really matter whether it's Risk or not. It really matters how it's marketed, because video game mechanics can't really be trademarked or copyrighted. You can copyright your art, you can trademark your branding, you can patent maybe some kind of software process behind something complex enough, something novel in the field, but you probably can't protect the basic mechanics of a world domination conquering game where you 5 armies and then you roll a dice, or you make a calculation and then see which army wins, and then you take over territories. There's probably no protection there. So Warzone has made a Risk clone. Warzone has tens of thousands of monthly active users, with users in every state of the United States. This is important because the common law trademark rights would then be in every state. Warzone has developed apps that are available for Android and iOS. A large section of the public is familiar with the mark. To date, it has over 750,000 downloads of the app version of Warzone through the app stores. Warzone has invested in developing and promoting the brand. Following its launch, a Google-powered search for the term Warzone would return Warzone's Warzone brand at warzone.com as the top result. That's a great sentence. Through its activities, Warzone has established reputation and goodwill such that consumers associate it with Warzone. Why is this important? Because trademarks are a source identifier. So the Warzone mark has to raise in their customers the idea that Warzone comes from Warzone.com, not Warzone comes from Call of Duty Warzone. The Warzone mark distinguishes Warzone from related products of other businesses. Warzone derives substantial benefit and goodwill from that consumer identification. Never in my legal career did I think that I went to law school and practiced as a lawyer and I'd be saying the word Warzone so many times in one story. On June 25th, 2020, counter-defendant Activision filed a trademark application to register the mark Warzone for use in connection with international classes 09 and 41 for downloadable video game software, downloadable video game programs, providing online video games, and providing information online relating to computer games and enhancements. Activision also registered the mark Call of Duty Warzone. This application is likewise for the same classes. They're going to call them the Activision applications. These applications were published for opposition on November 3rd, 2020 in the official Federal Register or Trademark Gazette. This is just part of the process of applying for a trademark. You have to publish the trademark, and interested parties are supposed to keep some kind of alert or read these things and make sure that no one is registering a mark that's similar to theirs. Counterclaimant, so Warzone.com, filed a notice of opposition November 3rd as well. The opposition proceeding has been placed in suspension pending the disposition of this lawsuit. Activision claims March 10th, 2020 as the date of first use in commerce. So it's obviously the junior mark, right? Activision has been using Warzone and Call of Duty Warzone in connection with online and downloadable video games and services identical to those previously offered by counterclaimant in U.S. commerce. The USPTO cited the Activision applications as preliminary bars to the approval of Warzone.com's applications by virtue of the earlier filing date and the likelihood of consumer confusion. So now both trademark registrations are on hold pending the resolution of this dispute. The USPTO did not find the term Warzone to be descriptive in the Activision applications, nor did the USPTO find the term Warzone to be descriptive in Warzone's applications. Why does that matter? Trademark protection depends on it. Merely descriptive words like Joe's Auto Repair aren't automatically trademark protectable. People have to start to recognize that Joe's Auto Repair means that guy's shop over on that street in that town. And that's called secondary meaning. So once the use of that trademark is recognized by enough customers and maybe even some non-customers, but people who are interested in auto repair maybe, then Joe could get some kind of trademark protection. But what we really want are suggestive trademarks or arbitrary trademarks or fanciful trademarks, like Apple for computers is an arbitrary trademark. You've chosen a word arbitrarily that does not represent computers. It does now, but back when it was chosen, Apple did not mean computers. Xerox is a made-up word. The word does not exist before Xerox made Xerox, or it did not exist, I guess, as a colloquial word. I don't really know the origin of the word, but Xerox is widely considered to be a fanciful trademark, a made-up word, a fancy word for their brand. So those are the strongest kinds of trademarks. Then you have suggestive trademarks. I'm trying to think of one. Coppertone, for example, is a suggestive mark because at the end of your tanning adventure, you're going to have copper-colored skin. The tone of your skin will be copper. So Coppertone itself doesn't mean tanning oil, but it suggests it. So that's also a level of trademark distinction that warrants trademark protection. As such, the USPTO determined that Warzone is inherently distinctive of the party's goods and services, which is a short way of saying everything I just said. Furthermore, the USPTO found the parties' respective Warzone trademarks are confusingly similar. Indeed, Activision seeks relief from this court that would bar the registration of Warzone.com's pending applications. Then they go into the examples. I don't think anyone really needs super great examples to reinforce that both parties are using the word Warzone. But Warzone.com wants you to know that Call of Duty is not just marketed as Call of Duty: Warzone. It's also just marketed as Warzone. You see, Warzone is the big text here and here. Then they go into some sales numbers, that it's a popular franchise, that they broadcast on Twitch. Once Counter Defendant adopted the Warzone mark, which means Activision, it buried Warzone's ranking in internet search results, which led to consumer confusion, diverted customers, lost sales, and weakened trademark rights. We can probably start skipping the rest of this. They claim unfair competition and trademark infringement. Unfair competition and false advertising under California law, and trademark infringement under common law. And they ask for an injunction permanently enjoining and restraining Activision from imitating, copying, or making unauthorized use of the mark, manufacturing, importing, exporting, distributing, circulating, selling, offering for sale products bearing the unauthorized reproduction, using any mark confusingly similar, or engaging in any other activity constituting unfair competition, making any statement or representation that falsely designates counterclaimant Activision as the origin of the goods, and engaging in any other activity for the purposes of circumventing, evading, or otherwise violating the provisions set forth above. Warzone.com wants monetary damages for reverse trademark confusion, costs and attorney's fees, as well as punitive damages and any other relief. That was filed back on June 8th in response to Activision's lawsuit, which was a complaint for declaratory relief saying that Warzone.com and Call of Duty Warzone are not confusingly similar, and they want the court to allow Activision's trademark to go through. In my opinion, there is a way through this that might have resolved it if Call of Duty Warzone had simply registered a trademark on Call of Duty Warzone instead of just Warzone. I mean, they did do the other one, but they also registered just the mark Warzone. That might have been a way to get around or through this matter without a big dispute like this. When I've registered trademarks for myself and for others in the past, sometimes there's a word in the trademark that you don't want to claim that word, you want to claim the whole thing. So you only want to claim Call of Duty Warzone, and you have no intention of claiming just the word Warzone. You can insert a little disclaimer in your trademark application, and the trademark office will put it through, because now it's been broadcast, communicated to the whole world that you're not claiming that just the one word. You're claiming the whole mark, Call of Duty Warzone. So I think that would have been a way through the thing. So now Activision files a motion to dismiss and requests judgment on the pleadings, which is kind of like summary judgment. You avoid a trial, but it's at the beginning. It's saying that the pleadings themselves show enough of the controversy that the judge can just rule on the thing right away without hearing anything more. So Activision now says, this case presents a textbook example of trademark overreach. Defendant Warzone.com, the counterclaimant, is a game developer that distributes a game titled Warzone. Though counterclaimant's Warzone is just one of more than a dozen games whose titles include that common English word Warzone, by this lawsuit, counterclaimant seeks to prevent plaintiff Activision from using the word Warzone as a subtitle for an installment of its enormously popular Call of Duty series of games. At first, this sounds a little bit disingenuous because they've always called the thing Call of Duty. I was a player of the original Call of Duty game. I really enjoyed it. And I think that they've sort of veered away from the original game a lot. And now it's more of like a modern warfare game, which I guess there is an installment called Modern Warfare. But they chose to add the name Warzone, this common English word, but that's not how trademarks work. Just because a word is also a common English word doesn't mean you can't use it as a trademark. Apple is a common English word, but Apple Computer can still use it as a trademark. So it's a weird start to attack on these grounds. For a variety of reasons, I'm assuming they're going to discuss them, it is unlikely that the single word Warzone has acquired secondary meaning as a source identifier for counterclaimant's products. Counterclaimant does not possess and has never possessed a trademark registration for that word in connection with video games. And at the time of the filing, that's true, but it does seem like counterclaimant has now made a trademark application. But irrespective of whether counterclaimant possesses any trademark rights in the word, and assuming that it does, counterclaimant cannot claim for itself exclusive use of the word Warzone in the title of expressive works about war zones and military combat. This is because the law is absolutely clear in this circuit and elsewhere that the First Amendment restricts trademark claims arising from titles of expressive works, video games, books, records, films, especially where, as here, the title is a common English word that has a meaning other than to designate the source of the good or service. Thus, numerous courts, including this one, have dismissed similar claims arising from titles such as Empire, Rebellion, Mastermind, Hidden City, Route 66, and others. And my initial response to that is, well, wait, you're trying to claim Warzone is a trademark of yours, so how is it that Warzone.com can't use Warzone, but Activision Call of Duty Warzone can use Warzone? That sort of makes no sense, and I think the counterclaimant points that out in their next response. The Ninth Circuit articulated the policy and rationale behind this body of case law 2 decades ago. A title is designed to catch the eye and to promote the value of the underlying work. Consumers expect a title to communicate a message about a book or movie, but they do not expect it to identify the publisher or producer. Thus, when analyzing trademark claims involving the titles of expressive works, courts in this circuit do not apply a likelihood of confusion test, but instead require the claimant to first overcome the 2-part test set forth in Rogers v. Grimaldi. Specifically, in order to proceed with its claims, counterclaimant must prove that Activision's title has no artistic relevance to the underlying work, and that Activision explicitly misleads customers as to the game's association with counterclaimant and its products. Counterclaimant's answer and counterclaims confirm that it cannot prove either element of the test. There is no dispute that Call of Duty Warzone is artistically relevant to the content of the expressive work it describes, a video game depicting a virtual war zone. Well, that just means that it's descriptive, and it doesn't get trademark protection until you show secondary meaning. How can you show secondary meaning, which I will freely admit they could if there was no underlying dispute, but how can you show secondary meaning when there is a dispute as to the trademark, the underlying trademark? Somebody else uses Warzone, you use Warzone, and you're trying to claim your rights are superior while saying that Warzone is not to be used as a trademark. It's a little weird for an argument. Further, counterclaimant does not even allege that Activision explicitly misleads customers as to any association with its own Warzone game. Accordingly, dismissal is appropriate. At base, counterclaimant's lawsuit is premised on its apparent annoyance that Activision's game is more popular than counterclaimant's game and thus now appears before counterclaimant's game in a Google search for the word Warzone. Whether or not this is true, it is not trademark infringement. To the contrary, when counterclaimant chose a common English word for its game title, it ran the risk that others might also use that word to describe their game, movie, book, or other creative endeavor. Now, Warzone.com did plead that the USPTO said Warzone is not merely descriptive. So I don't know how well this argument's going to do. Activision was entitled to select a title for its game that accurately reflects the content of that game and does not mislead consumers, since the title, Call of Duty Warzone, accurately communicates a message about the game itself and does not falsely purport to be associated with counterclaimant, Warzone.com. Counterclaimant's counterclaims should be dismissed, and the court should grant a judgment in Activision's favor. And they go over a lot of the facts here. We're going to skip a lot of this. Because counterclaimant answered Activision's complaint and admitted some things, Activision seeks judgment based on those admissions. So that's the basis for the judgment on the pleadings. So what happens next then is Warzone.com gets a chance to respond. Randy Ficker, the video game developer and Warzone.com's founder, asserts that they have 80,000 active users, or at least at one point they did, that they have 750,000 downloads on the app stores, and goes on to object to Activision's registration of the Warzone mark. He accuses Activision of being the party overreaching in its bold attempt to usurp and trample over Warzone's superior and senior trademark rights under the guise of free expression, while simultaneously seeking exclusive trademark rights for the very same word and goods and services that Warzone is seeking to enforce. The hypocrisy and abuse of process is undeniable. If we are going to reduce this dispute down to textbook examples, then what we have here is a classic case of reverse trademark confusion. This is something new to me, and we're all going to learn together. Reverse trademark confusion occurs when the junior user's advertising and promotion swamps the senior user's reputation in the marketplace, such that customers are likely to be confused into thinking that the senior user's goods are those of the junior user. Sounds like some kind of piggybacking. I doubt that Call of Duty Warzone needs to piggyback off of Warzone.com, but that does appear to be an accurate representation of what happened here. Whether it's trademark infringement, I will leave to the judge to decide. Activision argues that its use of the Warzone mark as the title for a competing video game is protected under the First Amendment. However, Activision's motion raises legitimate concerns about the balancing test used to evaluate trademark and First Amendment rights. When an identical trademark appears in the title of a competing expressive work, and where the senior user asserts a claim of reverse confusion, the balance advocated for by Activision tilts too far in favor of the junior user's First Amendment interests. If this case is prematurely dismissed at the pleading stage, it would effectively mean that a senior user's trademark is worthless and unenforceable. It would signal that a corporate giant can claim the mark of a direct competitor without the claimant even being afforded an opportunity via discovery to explore the issues presented, merely because the defendant is using the claimant's mark in the title of an expressive work. And it's great, they're appealing to the judge's sense of what are the consequences of this. But I'd like to see more upfront discussion of how they overcome the Rogers test that Activision accused them of failing, and answering the claims directly. So they're concerned that a large corporation can just come in and take the trademark rights by using a similar mark in a larger product. The Ninth Circuit has recognized two distinct claims in the trademark infringement context: forward confusion and reverse confusion. Forward confusion occurs when consumers believe that goods bearing the junior mark came from or were sponsored by the senior mark's holder. By contrast, reverse confusion occurs when consumers dealing with the senior mark holder believe they are doing business with the junior one. This occurs when the junior user's advertising and promotion swamps the senior user's reputation in the market, and customers are likely to be confused into thinking that the senior user's goods come from the junior user. Courts have recognized a number of adverse consequences. For example, the senior user may be foreclosed from expanding into related fields, which is protected by trademark, and misconduct, or problems with the junior user and its product could negatively impact the goodwill of the senior user if it was unfairly associated. Courts recognize the reverse confusion theory to prevent the calamitous situation where a larger, more powerful company thus usurps the business identity of a smaller but senior user. Here it is undisputed that Warzone is the senior user of a Warzone trademark, and Activision is the larger, better-known junior user. Activision's marketing and promotion of its own Warzone video game in connection with one of the best-selling video game series of all time, Call of Duty, has swamped Warzone's superior rights, etc. Activision's infringement is not protected by the First Amendment. It argues First Amendment concerns regarding application of the balancing test developed in Rogers v. Grimaldi. In Rogers, the Second Circuit found the Lanham Act should be construed to apply to artistic works only where the public interest in avoiding consumer confusion outweighs the public interest in free expression. Under the two-prong Rogers test, an expressive use of a trademark in the title of a work is not actionable unless the use of the mark has no artistic relevance or explicitly misleads as to the source of the content of the work. Whereas here, free expression concerns do not outweigh the public interest promoted by the Lanham Act, the First Amendment is no defense. Indeed, the First Amendment cannot permit anyone who cries artist to have carte blanche when it comes to naming and advertising his or her works, art though it may be. This court has held that the First Amendment does not automatically insulate all artistic works from liability under the Lanham Act. Further, the Ninth Circuit noted that the First Amendment offers little protection for a competitor who uses a confusingly similar mark on its commercial goods. Activision is therefore not entitled to absolute protection from liability under the Lanham Act, the Trademark Act, because it created an artistic work. A title can function as a trademark and as a source identifier, which removes it from blanket First Amendment protection. So, for example, I couldn't use the words Harry Potter in the title of my video without really getting close to or crossing over the line into trademark confusion, even though it's a title. So if what Activision is saying is true absolutely all the time, that anybody can just go use Harry Potter because Harry Potter is a title. No, Harry Potter is also the source identifier for books from J.K. Rowling. A title can function as a trademark and source identifier, although the title of a single book cannot be a trademark because it does not serve as a source identifier. That creates an association between the book's title and the source of the book. The name of a book series, however, may serve as a trademark function because the name indicates that each book of the series comes from the same source as the others. Unlike the movie title in Rogers, which served merely as the name of a single movie, Activision uses Warzone as a source-identifying trademark for a video game series that competes directly with the trademark owner. Although Activision also uses Warzone in the title Call of Duty Warzone, it promotes its game under the word Warzone in the manner that emphasizes and claims trademark rights in Warzone on its own, separate and apart from Call of Duty. Its marketing displays the TM symbol next to the word Warzone, and Activision has filed to register Warzone on its own as a trademark for goods and services with an identical description to those previously offered by Warzone. Warzone does not dispute that video games may qualify as artistic works subject to the application of the Rogers test. However, Warzone submits that the title of Activision's game is Call of Duty Warzone, not merely Warzone. So that's a pretty good response, I think. I don't know how the judge is going to rule, but that's a very strong response. They don't have a title Warzone. They have a title Call of Duty Warzone. So the First Amendment doesn't apply the same way here. Activision's motive in choosing also to refer to its game by Warzone as the trademark for its billion-dollar video game franchise was gratuitous, willful, and not part of an artistic title. In essence, Activision is claiming the entitlement to two titles, both of which it has applied to register as a federal trademark, and one of which is identical to Warzone's mark. Discovery of information exclusively in the control of Activision is needed to fully understand whether its video game is both an artistic work and a commercial work, and the circumstances surrounding how and why it chose Warzone as a trademark given Warzone's superior rights. So most recently, Activision has then responded to that, sort of doubling down. This is a very similar table of contents to the previous one. Here's the table of contents for the reply, and here's the table of contents for the motion to dismiss. They are very close. Counterclaimant admits that Call of Duty Warzone is an expressive work and that the word Warzone is used by Activision as part of the title of that expressive work. So again, we're back to why didn't they just call it Call of Duty Warzone, since Warzone is only part of the title. This alone is sufficient to require application of the Rogers test because the only threshold for applying the Rogers test is whether the allegedly infringing use is contained in an expressive work. First, counterclaimant seems to suggest that a video game title cannot serve both an artistic purpose and a commercial or marketing purpose, including serving as a trademark or brand. This is incorrect. Rogers specifically notes that titles, like the artistic works they identify, are hybrid, combining artistic expression and commercial promotion. The title of a movie may be both an integral element of the filmmaker's expression as well as a significant means of marketing the film to the public. The plaintiff in Rebellion made the exact same argument. Defendants are using Rebellion as a trademark because defendants in fact filed a trademark application for the mark. Plaintiff's arguments against use of the Rogers test are unpersuasive. The Rogers court itself recognized that titles of literary and artistic works could acquire secondary meaning and become eligible for protection as trademarks. Well, isn't that what Warzone.com is arguing? Rogers also did not include in its test any inquiry as to whether the title can or does function as a source identifier. The Rebellion Court's conclusion is consistent with the law in this circuit. It is well established that even overtly commercial or promotional uses of a movie, television program, or video game title, including in merchandise and other ancillary products, are fully entitled to First Amendment protection. So I can go make a video game called Call of Duty and market it, and Activision is not going to have a problem with it? I doubt that. For example, in Empire, the defendant engaged in extensive promotion and exploitation of the Empire title, including by using it in advertisements, consumer products, sound recordings, live events, and personal appearances. The court held that all of these were fully protected by the First Amendment. It requires only a minor logical extension of the reasoning of Rogers to hold that works protected under its test may be advertised and marketed by name, and we so hold. Other courts have come to the same conclusion in similar circumstances. Maybe I'm missing something here. I certainly could be, but it sounds an awful lot like they're saying that because Call of Duty is the title of the video game, that anybody can go use Call of Duty in their title, and Activision can't do anything about it. And I seriously doubt that that's true. Second, counterclaimant argues that the Rogers test does not apply, or that it should be modified or altered, when the claim is for reverse confusion or involves related or competing products, but courts have consistently held that Rogers applies to claims for reverse confusion, contradicting claimant's argument that the factual circumstances of reverse confusion do not fit neatly into a Rogers balancing test. Then they cite to 1, 2, 3, 4, 5, I think 6 or so different cases here. There is no logical or public policy reason why Rogers would not apply to claims of reverse confusion. The ultimate inquiry is exactly the same. Whether the claim is for forward or reverse confusion, whether members of the public are likely to be confused or deceived into believing that the defendant's product is associated with or originates from the same source as the plaintiff's product. Third, counterclaimant cannot avoid application of the Rogers test by arguing that Activision's use of its Call of Duty Warzone title does not refer to counterclaimant's own trademark or lacks cultural significance. The Ninth Circuit has made very clear on many occasions that neither is required for First Amendment protection. In any event, counterclaimant's cultural significance argument misses the point. What is relevant is not whether the mark is culturally iconic, but whether it has any expressive purpose other than as a source identifier for claimant's product. That plainly is the case here because the word Warzone is descriptive and has a linguistic meaning that has nothing at all to do with counterclaimant. But I go back, the USPTO allegedly has said that Warzone is not merely a descriptive mark, but is something more than that, maybe suggestive or something. So it has trademark protection. We just don't know who gets the trademark protection in this particular case yet. Warzone.com developer has started a GoFundMe to help pay for this effort because this is going to be a relatively expensive effort. They've raised $26,000 of $50,000 at this time, and Randy Ficker writes, "I'm being sued by Activision for being an indie game developer. I launched Warzone in 2017. In 2020, Activision launched Call of Duty Warzone and is now suing me to steal the name, banking on my limited resources." That is something that happens. I can't tell you if that's what Activision is doing. I don't have any knowledge of that. You can certainly decide for yourself whether Activision has used its prowess to overpower Randy here in his use of the Warzone name. Now, one question that I have is whether, and we don't know this, we will never know this, would Activision have sued Warzone.com if Warzone.com had not opposed Call of Duty's application? What might have happened is Call of Duty Warzone, the trademark, gets registered, Activision's application for Warzone gets granted, and then they go after Warzone.com. So Randy needs this in order to at least protect his game a little bit, because the next thing that happens after this is that Activision, in my opinion, the next thing that happens is that Activision goes after Warzone.com, even if he didn't oppose their trademark. He says, "I love making games. The game is my full-time job. It surprised me when they named it Warzone, Call of Duty Warzone. That's the exact same name as my game. Trademark law says that whoever uses a name first gets rights to it, just like someone can't make a game named Minecraft today. However, Activision thinks these laws don't apply to them." And looking at that, let's go to the Minecraft example. Can Leonard French go make a mining and crafting game and call it Minecraft and then say, well, Microsoft can't own the Minecraft trademark because it fails the Rogers test that we just read about? It doesn't really make any sense to me, and I'm not sure who's right here. So I'm really curious and interested in the adjudication of this lawsuit and what the judge will have to say at the end of it. So April 8th, Activision filed a lawsuit. They used the Wallace Shawn meme from Princess Bride. It's inconceivable that any member of the public could confuse the two products, according to Activision. And so Randy says, inconceivably, I get contacted all the time from people who are confusing our two games. People tell me about how their Xbox can't connect, or how their PlayStation got hacked, how they wish they could carry teammates, etc. My game isn't on Xbox or PlayStation. I send the same reply to each of them. Warzone and Call of Duty Warzone are two different games. You should contact Activision. Years ago, I set up a category on Twitch for fans of my game to stream it. Today, it's filled with people streaming Activision's game. Go look at it right now. Okay, let's do that. Here is the game Warzone, and yeah, it looks like it's Call of Duty Warzone. Even though the game is obviously Randy's icon here from his game Warzone, which uses that same logo. Activision consistently has marketed and promoted Call of Duty Warzone as part of the Call of Duty franchise. They provide this picture, except that they don't. On Activision's website, they shifted their logo up to crop out the words Call of Duty, leaving only Warzone and a bunch of blank space at the bottom. They say, welcome to Warzone. Warzone is a giant sandbox. Warzone was developed with all playstyles. Warzone's Battle Royale mode. Warzone also features. All progression earned in Warzone will count. In addition, Warzone shares the same item shop. For players who already own the full version of Call of Duty Modern Warfare, Warzone automatically becomes part of your game experience. This can be found everywhere. Press releases, blogs, support pages, newsletters. It seems to me that they call their game Warzone, not consistently Call of Duty Warzone, as they're alleging in the lawsuit. So this whole thing could have been avoided if they had just called the damn game Call of Duty Warzone, instead of trying to take over the Warzone name. It seems like it's Activision who's overreaching, but I'm not saying that as a legal conclusion. I'm saying that as a personal opinion. After all this, Activision still claims that it's inconceivable that any member of the public could confuse the two war zones. How you can help: 100% of the funds raised here will be directly used for the legal fight against Activision. If you can only contribute a few dollars, it will still help by showing support. If you can't help with funding, you can help by sharing this page. The law is clear. If you use a name in commerce before someone else, they can't sue you to get the rights to that name. For the record, I love Activision's games. There are a lot of hard-working game developers working for Activision, probably like myself, creating fun experiences for the world to enjoy. My beef is with Activision's legal department, who is trying to squeeze an indie game out of existence. Thank you for supporting indie gaming. So if you want to support, if you choose to support Randy Ficker, you can go to GoFundMe and search for Activision is suing Warzone. I'll provide a link in the description. How do you feel about this fight? If you were in Randy Ficker's position and you developed a game that nobody else was using your name for a widespread game, and you made your game, forgetting the fact that it's a Risk clone that has nothing to do with how protected a trademark would be, then I would feel really crappy. I would feel bullied if someone came and used the same name. If someone made, Lawful Masses, the legal education service, and tried to say that I hadn't been using the name in a trademark protectable way for the last 5 years, I'd feel really bullied by that. And I would want to defend myself. So I can understand Randy defending himself. I personally, professionally, do not know how this is going to go. I'm fascinated by trademark, which is how I got involved in copyright. I was fascinated by copyright, and now I'm a copyright attorney and feel like I'm some kind of authority on a particular kind of copyright case. I get calls from other attorneys all the time asking me to help them get through their copyright piracy case. So I am not that well versed in trademark. I do not consider myself to be competent enough to represent in this level of trademark dispute. This is me as an attorney interested in a case and sharing with you my exploration and my thoughts on the case. So I want to hear your thoughts. What do you think of the dispute? Do you think that Activision should just have registered Call of Duty Warzone and not just the Warzone trademark as a separate registration? Do you think that because Activision's bigger and Warzone is just a clone, it doesn't really matter? Just let Activision have the trademark. Should the parties settle and agree to somehow share the trademark in some way, which that's a risky venture, because if one of the parties does something that hurts the other party, how's that going to be adjudicated? We're going to be right back here. So let me know what you think in the comments below. There's also the legal arguments. Do we have any attorney viewers who understand the Rogers test way better than I do and have an opinion on how this will play out? Is Activision right, or is Warzone.com and Randy Ficker right? Let me know. And that's our show. Thank you for watching. Special thanks to our top supporters in October: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, ShadowTycho, Earthbound Star, PureMagma, Drew Hart, TechTechPotato, and Eric Tams. You can support Lawful Masses on patreon.com/ljfrench and sponsors.com/law, or through YouTube memberships and through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.